It's Conduit News Radio with Paul Harrell.
All right, folks, welcome back to the program. Hey, joining us in studio, we got State Representative Jimmy Gazaway. Jimmy, welcome back to the program, sir.
Good morning, Paul. Thank you.
Let's talk a little bit about Issue 1. That's why I wanted to have you on. You have been going all over the state or different venues and that sort of thing, talking about Issue 1 and why it's not a good policy, why it's not a good amendment that needs to be voted for. And so tell us why Issue 1 is bad in your opinion, Jimmy Gazaway.
Well, it's hard to narrow it down. I mean, there's so many reasons why it's bad. But you're right, I have been speaking all over the state about it. And I think primarily, it's just bad for everyday Arkansans. It does several things, first of which is, it limits people's ability to hire the lawyer of their choosing because it limits the amount of money that an attorney can make off a case on attorney contingency fees. And, the point there being, they'll claim that it's to rein in greedy lawyers. Mm-hmm. But the fact is that if you can't get a lawyer to take your case because a lawyer can't make any money with that case, then your case never gets brought. And if your case is never brought, then those who may have done you wrong are never held accountable, which is exactly what they want. So they'll claim it's to rein in greedy trial lawyers. It's not about that. It's about preventing you from being able to get a lawyer, because if they can prevent you from being able to get a lawyer, then you never bring a claim and they're never held accountable, which is exactly what they want. The second thing that Issue 1 does, and that I think, to me, is just the most disgraceful thing about it, are the damage caps. Issue 1 will cap non-economic damages at $500,000. And so, then the question is, well, what are non-economic damages? And a lot of people don't understand that because the proponents of Issue 1, one of the things you'll hear them say so often is, well, economic damages are unlimited. You can get all the economic damages in the world. They're completely unlimited. Well, that's true. But what if you're a person who doesn't have any economic damages? What if you don't have a job? What if you're someone who's confined to a nursing home? Okay? They don't work. There's no hope that they'll ever work. There's not going to ever be any economic damage with somebody like that. Mm-hmm. And so if a person who has no economic damage like that is abused or killed, you're talking about $500,000 maximum compensation for them. And so what are non-economic damages? They're the damages that we define in the law as those for pain and suffering, for scarring and permanent disfigurement, for loss of a bodily member or function. So, for example, you lose an arm, you lose two arms, you lose all your limbs, you're paralyzed.
Yeah, I saw an article against Issue 1. It was talking about somebody losing their sight. That would be covered as under this as well.
Absolutely. Right? Loss of a bodily function, your ability to see, and then loss of life. And so that's why you hear it so often referred to as the price of life amendment. And you see, those who are opposed, like me, say that it puts a price tag on life. Because if you have no economic damage, and there are a lot of people in our society who don't, those confined to nursing homes, for example,
yeah.
Then the maximum amount of money that you'll be able to be awarded, because your only damages are going to be non-economic. And so the maximum amount would be $500,000. And what a miscarriage of justice for people who are abused or die because of the neglect of someone else, to say that the maximum amount of recovery that they can receive because the survivors for their loved one's death is $500,000. That is morally wrong. And that's why you see people like Jerry Cox at the Family Council and Rose Mims, not in her capacity with Arkansas Right to Life, but in her personal capacity. That's why you see those folks come out against this, because morally that is wrong.
Yeah, I completely agree with what you're saying. I'm glad that you're coming on and you're making these points. You also have an incentive factor to look at here when it comes to, does a business, nursing home, trucking company, insurance company, whatever, do they have an incentive once they have done something wrong that's resulted in a death or disfigurement or whatever? do they have an incentive to make sure it doesn't happen again to somebody else? And if you cap it at 500,000, the nursing homes are just going to have it's going to be an itemized thing. How many times we get sued if they can find a lawyer?
That's right.
How many times do they get sued? All right, well, now it's just on an Excel spreadsheet. It's a cost of doing business. Every couple of years, we're going to pay $500,000 or less to somebody somewhere for killing somebody or doing something. And once that gets just kind of factored in, you don't really have an incentive to do right. Talk about greedy trial lawyers. Are you kidding me? This is about greedy big business. This is about greedy nursing homes. And I'd like to ask you, Jimmy, and we're talking with State Representative Jimmy Gazaway. We've got a judge who's in jail for taking a bribe from nursing homes, or a nursing home owner, allegedly. Only in Arkansas can you have a bribee, but we still don't have any charges against the briber. But this judge pled guilty for taking $10,000 to lower a nursing home judgment that was against a nursing home. We have convicted felon Jake Files in the discovery. We know when when the bill was filed, I think by it was Eddie Joe Williams at the time, filed this situation's predecessor, this bill's predecessor. He got $80,000 from a nursing home owner right after it was filed. And it's like only in Arkansas do with all that information, this thing still gets on the ballot under, a lot of, push from, the party that's in charge. And so is that just, they want to talk about special interest. Well, this is special interest. The reason we are voting on this is because of special interest.
Well, you're exactly right. I mean, I've heard some people refer to it as, I refer to it as the Price of Life Amendment. I've heard some people refer to it as the Special Interest Protection Act because, the folks who are behind it, I mean, let's just be honest about it. It's the special interest. It's the nursing homes who, like you said, there's a former circuit judge who's in federal prison today because he pled guilty to accepting a bribe from a nursing home owner in the form of apparently a really large campaign contribution. There are the other allegations that you mentioned, and I think that's under investigation. We'll see what happens with that.
Yeah.
I don't want to accuse anybody of anything. You never really know. So I'm
right,
not going to go there. But the circuit judge pled guilty
Yeah.
to accepting a bribe. And so, who's behind this? The nursing homes, the trucking association, the medical society, the healthcare association. It's all the normal players. And like you said, one of the things I hear so often about this is, well, I'm a conservative, I'm a Republican, and conservatives and Republicans believe in tort reform. So shouldn't I be for this? I mean, isn't this a conservative thing? And one of my responses to that is, this is not about Republican versus Democrat. This is not about, conservative versus liberal. The fact is, this is the history. You can go look it up. There's been tort reform offered in Arkansas. You can go back to 2001, 2003, back in previous legislative sessions when the legislature was controlled by Democrats. I mean, go back and look at those bills and look who the sponsors on them were.
Yeah.
They were Democrats. The vast majority of the legislature in 2003 was controlled by Democrats. Here's the point. The legislative environment is the swamp, okay? And the swamp is still there. It's always been there. It's still there. It's just the alligators have changed from blue to red. Mm-hmm. And the players just, it's the same players in a lot of instances. They've just swapped a blue jacket for a red jacket. It's not about Republican versus Democrat. It's about the special interests trying to get their way.
Yeah, and they want to insulate themselves from having to, to pay out, this money. Let's talk about the other thing this does. It lets the legislature set rules of evidence for the judicial branch. It's a clear violation of the separation of powers, in my opinion. So talk a little bit about that. I don't trust the swamp to set these rules any more than I trust the judiciary to set them. I'd rather it be where it's supposed to be, in the courts.
Yeah, right. Yeah, that's the other thing about it. So there are three parts primarily, and I kind of touched on the attorney part.
Mm-hmm, mm-hmm.
If you limit attorneys' fees where they can't make any money on a case, then you'll have people who may have legitimate claims who won't be able to get a lawyer, who won't be able to bring that claim, and no one's ever held accountable. The second part, the damage caps, of course, which I talked briefly about. One thing that I didn't mention in there, and you talked about being able to hold those responsible for harming others accountable, and that is not only does it cap non-economic damages, again, which are pain and suffering, scarring and permanent disfigurement, loss of a bodily member or function, loss of companionship, and loss of life. Not only does it cap all of those things at $500,000, which are currently unlimited. Right now, if you went to court in Arkansas, you can be made whole as a victim of, abuse or neglect or being ran over by an 18-wheeler or nursing home abuse, whatever. The courts have the ability to make you whole. If that $500,000 cap for non-economic damages passes, they won't have the ability to make people whole again. But then the other portion of that cap is the cap on punitive damages, which it caps at $500,000 or 3 times the compensatory damages. In other words, the total amount of damages. Well, here's the problem with that. We live in an economy of scale. Mm-hmm. And you may have seen recently, the news reports where Apple was the first corporation ever to reach $1 trillion valuation.
Yes.
Did you see that?
Yes, I did. Yeah.
And I think Amazon's right on its heels. Amazon
mm-hmm.
will probably be worth $1 trillion pretty soon. And punitive damages are those damages that we recognize in the law that are used to deter future bad conduct. In other words, they're used to punish bad actors, to deter them from ever doing that thing again. And what Issue 1 will do is it will limit punitive damages to $500,000 or 3 times the compensatory. And I don't mean to make $500,000 not sound like a lot of money, because it is. But again, in an economy of scale, where you're talking about you have corporations valued at $1 trillion.
Yeah.
Many of the Fortune 500 companies, multiple billion dollars. Big Pharma, for example, you have CVS Caremark is buying out the insurance company Aetna.
Yep.
And I think they're my understanding is they're paying cash of like $60-something billion. And you're going to say $500,000 in punitive damages to a company like that is going to deter their future bad conduct?
It's nothing.
I mean, what a joke.
It's a drop in the bucket. Yeah.
I mean, $500,000 again is a lot of money. But when you're $1 trillion corporation, or when you're a multi-billion-dollar corporation, is $500,000 or 3 times the overall compensatory likely to deter future bad conduct?
They won't change their behavior at all.
No.
Yeah, not at all.
So, let's be real. But the last
That's
part.
truth right there. That's State Representative Jimmy Gazaway. That's a lot of truth. Go ahead.
So the last part that you mentioned, so I wanted to get to that too, which is the rulemaking authority. And, I've said that, this could be maybe the most dangerous part. I mean, it's certainly the most insidious. In other words, people aren't going to recognize its true danger, and they knew that. Mm-hmm. But this may be the part that they want the most, because if you can control the rules, you can control the outcome. Okay? So let me give you some examples, like some of the rules of evidence, for example, in a case. If you can control what evidence is admissible in a case, so maybe they change the rules of hearsay to where, you have somebody, well, I know this happened, somebody told me that. Well, you're not going to be able to say that in court. You'll never be able to get it in and get it admitted. If you can't get it admitted, maybe you can't prove your case. The rules of discovery, for example, and that's one of the big ones. Discovery is that portion in a lawsuit where you can request documents, you can make the other side answer questions, you can take depositions. It's where you build your case. It's where you gather the evidence from the other side that you need in order to make your case. Mm-hmm. Well, guess what? If they can control those rules, they can keep things secret that maybe not allow you access to things. So, for example, one of the bills that they tried to pass in the past was to make nursing home inspection reports, not eligible.
Yeah, that's hearsay.
To be able to obtain or to use those mm-hmm. in court. Or let's say you want to subpoena witnesses to help make your case. One of the things, my understanding, that's been proposed in the past is if a nursing home employee would have to get the permission of the nursing home owner to testify as an expert witness in a case, or something along those lines. And even if that's not exactly what they did in the past, if they can control the rules, that may be the things that you'll see in the future. Now they'll say, "Oh, we don't want to do that."
That's ridiculous. I mean, we can't control what future legislators are going to do.
Right.
You know, even if we believe them now,
That's right.
they're going to be. They're different people.
Yeah.
You know.
So, maybe not the next session, but what about the session after that?
Yeah.
Let's
Yeah.
see where it actually goes. So that, to me is one of the most dangerous things about it. That's hidden out there. Or, another point there, if you can control the rules, you just make it really hard to file a lawsuit. Maybe you have to go to arbitration before you can file your case. Maybe you have to, make the rules for subpoenaing witnesses and getting the people to court that you need there so hard, and that you have to go through so many steps and so many days notice and this and that and the other thing, that it makes it so hard to ever even bring a case.
We're talking with State Representative Jimmy Gazaway about the dangers of Issue 1. We will all be voting on this in a couple of weeks. Early voting starts, I think, is it next week? Or I think so. November 6th is the election day. And so, Issue 1's bad. It doesn't need to happen. This is, special interest dream. I want to give you credit. Not only State Representative Jimmy Gazaway are you going across the state and speaking against this, but you actually tried at the very beginning to stop this using your power as a legislator. You, correct me if I'm wrong, you offered an amendment, or you offered another bill entirely that would have done some tort reform, but not this. Tell us about that.
Yeah, absolutely. I ended up offering an amendment, and I think this is something else important for, the people that aren't at the Marble Palace all the time, who don't know exactly what's going on. It's important for them to understand the process and kind of how all this came to be. There were multiple constitutional amendments introduced this last legislative session. Certainly upwards of 10, may have been even around 20. I'm not exactly sure of the number, but it was everything from the ones you're going to see on your ballot. This Issue 1, voter ID. There were some about education. There multiple topics and issues about how we amend our Constitution by initiated act and referendum. A proposed constitutional amendment to change the way we do that. There were multiple constitutional amendments offered. Well, where do those constitutional amendments go? The process is that those go to the State Agencies Committee. Well, guess who the chairman of the State Agencies Committee was?
In the House of Representatives?
Yes.
That'd be Bob Ballinger.
Correct,
Yeah.
who was the sponsor of the bill. Nothing against Bob. I like Bob. I consider Bob a friend. I think he really is genuine in what he believes. We just have policy disagreements. I just think he's wrong. He thinks I'm wrong. That's fine. We can disagree. But Bob was the chairman of state agencies. All the constitutional amendments go to state agencies. Bob was the lead sponsor on Issue 1, or it was SJR 8 at the time, in the House. It goes to his committee. Well, when I got elected to the legislature, excuse me, the Speaker appoints all the committee chairmen and chairman of subcommittees. And so I'm a new representative. I'm at the Capitol. The Speaker's making his appointments, and I see that I have been appointed as the vice chairman of the Civil Law and Courts Subcommittee of the Judiciary Committee. And I think oh, this is awesome, and I'm like, I'm the vice chairman. I'm a freshman, and I'm vice chairman of the Civil Courts and Civil Law and Courts Subcommittee. And Clark Tucker was the chairman of that, which should have told me something. You make a Democrat the chairman of, what does that mean? So I go to Clark and I said, hey, so when are we going to meet, like the Civil Law and Courts Subcommittee? And Clark just kind of laughed at me. He said, you don't understand how this works. He's like, subcommittees never meet. I was like, oh, okay. Unless you're the State Agencies Committee. Because what they did was they took all those constitutional amendments in state agencies and referred them to a subcommittee on constitutional amendments. And they said, we're not going to let the full committee consider all the constitutional amendments that have been introduced. We're going to let the subcommittee pick 4 that will be considered before the full committee. See what I mean?
Yeah.
So, at that point, I had filed, along with Brian King, he was the Senate sponsor, kind of an alternative tort reform proposed constitutional amendment. That never made it out of the subcommittee, okay? So they knew which ones were coming out.
Yeah.
And SJR 8.
They stacked the deck to get the results they
Sure.
wanted. Yeah.
So SJR 8 was one of them. So that comes out of the subcommittee. That's one of the 4 that come out of the subcommittee that goes before the full committee. The Chief Justice of the Supreme Court comes to state agency's House committee and testifies against SJR 8. And it felt to me as if it was completely disregarded. I mean, this is someone, the Chief Justice of the Supreme Court, the Chief Judge in our entire state judiciary, telling the state agencies committee, I believe this is bad. They didn't care. They passed it. And so then, after it passes out of committee, which was, I think, called on there was an amendment, and it was called after adjournment to consider this bill and amendment, SJR 8, and they pass it and put it on the calendar for the very next day to be voted on by the full House. So I go back and I'm reading the rule book, and I realize you can't do that. A bill has to sit on the calendar for so long,
right,
before it can be voted on by the full House after it comes out of committee. And this came out after 4 o'clock, and the rules say if it comes out at 4 o'clock, can't sit on the House calendar for long enough to be voted on the next day. So the next morning, I start making my objection. I say, I object to this being voted on today. Please note my objection. And they did. It's right there in the record. Representative Gazaway objects to this being voted on today. And so I knew at that point, maybe we had delayed it, and I think that was a Friday, and that would have given us the weekend to talk about it.
Right. And that's what they didn't want.
That's exactly what they didn't want. And so what happened was, and what I knew was possible, is that if you suspend the rules, then you can do anything.
Mm-hmm.
And so at that point, I had to kind of be on guard, and I was kind of led to believe by some people who had talked to me at that point, like, well, way to go. Like, we're really impressed. Like, nobody's ever used that rule before. But, now because of you, everybody will have to think about this and labor about it all weekend, and we'll vote about it on Monday.
Oh, God forbid that you actually have to think about it.
Well, I wasn't going to buy that, okay? I mean, because I know if they suspend the rules, then they can do anything. And so I'm thinking, maybe it's not going to be considered today. Maybe we'll have the weekend, for members to think about it and, consider alternatives and that sort of thing. And so then one of the representatives stands up and makes a motion to suspend the rules. Well, I know what's going to happen then. You see?
Right. Let me just stop you right here, Joe. Will you get rid? Well, hang on a second. We're going to have to take a break here in just a moment. So real quick, we've got like a minute and a half. So
sure.
Go ahead, Jimmy Gazaway.
So anyway, so at that point, I introduced an amendment, and so how do you make this better? Which is really what I tried to do. If you want to target this toward frivolous lawsuits, because that's what you hear about, that's their marketing campaign. Oh, this is about frivolous lawsuits. Well, the word frivolous is not found in the entire amendment. And so, let's focus on how we can actually reduce frivolous lawsuits. Yeah. Let's sanction attorneys who file frivolous lawsuits. Let's allow a judge to fine a lawyer who files something that's truly frivolous. Mm-hmm. That's how you do that. That's not anywhere in SJR 8. That was the very first thing in the amendment that I proposed. If we're going to have damage caps, which I don't agree with at all, but what my amendment did is it made an exception for cases involving death, because that doesn't put a price on life.
It's exactly right. Anyway, I really appreciate it. It's been very enlightening, State Representative Jimmy Gazaway. You've been against this from the beginning, and I really appreciate what you're doing. And hopefully, we'll probably need to have you on again because the way you lay out the case against this is very, very efficient. And so I appreciate what you're doing, and we'll do this again soon.
Sure, absolutely.
Right. Folks, we got to take a break. Back in just a moment.